Good afternoon, Craig. Can you hear me?
Yeah, loud and clear. You can hear me okay?
I can hear you okay. We're at the top of the hour, so we'll get started right away here. So for those who don't know me, my name is Greg Wood. I'm a financial advisor at Cochrane Wealth Management here in Cochrane, Alberta. Today we have Craig Colson, who's going to be presenting on wills and estates, executors, power of attorney, all that kind of stuff. We'll keep it sort of informal today as well. There is a Q&A button at the bottom of your screen. Anytime during the presentation, if you have a question, feel free to type those in. And if they're not answered through the slides, then at the end I'll ask those questions to Craig, who can then give us the answers. Of course, if you have more questions or you'd prefer more personal consultation, Craig is available for one-on-one meetings with all the Raymond James clients as well. Solus Trust is a estate and trust division of Raymond James. Important to know as well that Craig and his team are available to you as a resource. So Craig, I'm gonna just quickly give intro and read your bio here, and then I'll get out of the way and pass it off to you for the presentation. So Craig is based in Calgary, Alberta. He brings over a decade of experience in trusts and estates, with extensive experience in fiduciary services and wealth management. He provides estate, trust, and incapacity planning services to clients in Alberta. Prior to joining Solus Trust, Craig held an estate and trust consultancy role with a bank-owned trust company in Alberta. He also served as a senior trust officer, administering estates and trusts. Craig's practical knowledge in trust and estate matters was further developed over his 11 years as a supervisor with the Public Guardian and Trustee of Alberta. Known for his thoughtful approach and deep understanding of trust structures, Craig delivers tailored solutions that align with clients' long-term financial goals and estate planning needs, with a strong commitment to integrity and client service. Craig works closely with individuals, families, and professionals to navigate complex trust arrangements and ensure the seamless administration of estates. His expertise spans intergenerational wealth transfer, philanthropic planning, and corporate trust services. Craig holds a Bachelor of Arts degree from Simon Fraser University in British Columbia and is a member of the Society of Trust and Estate Practitioners Canada. So with that, I'll pass it off to you, Craig. And then just one more reminder for anybody who is just joining in last minute here, you can type in your questions by hitting the Q&A button on the bottom of your screen, and I will get to those at the end of the presentation. All right, the floor is all yours, Craig.
Excellent. Thanks, Greg. Hi, everyone. I think, Greg, you're just going to show the slides, or I can share my screen. So I'll just quickly get set up.
Yeah, if you share your screen, Craig, then you'll be able to drive the
Okay.
slides. If you have any
Okay.
issues, though, I can do it as a backup as well.
Okay. Let me just see what I can arrange here. Okay. There we go. Yeah.
I can see the
Oh,
slides now.
okay. Perfect. Okay. All right. Well, welcome, everybody. Thanks for the introduction, Greg. Yeah, I'm going to present some pretty high level stuff. And as the title says, how to choose your executor and why your friends or family will thank you for not choosing them. Um, it's a pretty daunting role to act as an executor, and it's one of those roles that I've often heard people say they've done it once, they'll never do it again, for lots of different reasons. There's not only the technical aspect of acting as an executor, and of course, you don't have to have any qualifications to do it, um, but it encompasses everything from a financial perspective in someone's life, from the most mundane tasks to, for example, of shutting off email accounts to and closing those off, to inventorying every last item in the home, dealing with beneficiaries, dealing with the court system, um, with the help of the lawyer, if you do choose to have a lawyer help you with the grant of probate application. And probably the most important role is dealing with CRA, although most executors will hire professionals such as an accountant to help them with that aspect. But before I get into some of those details, um, I'll just give my disclaimer that Solus Trust employees don't provide tax or legal advice. We encourage clients always to consult and rely on their own lawyer or qualified tax advisor regarding their specific situation, because it can be quite different. Um, I work for Solus Trust Company, which is a federally regulated trust company and an affiliate of Raymond James Limited. Um, and the services provided by Solus Trust are not covered by the Canadian Investor Protection Fund. So that's the legalities of it. So I'm just providing information to everyone here today. So its most basic concept, a will is indeed a legal document. From an Alberta perspective, which is where I'm based and in what I know best, um, uh, the legal document in Alberta can be either formally produced by a lawyer, or you can have what's called a holograph will in Alberta, which not every province allows for. A holograph will is a document that's in your own handwriting, and in Alberta, does not even need to be formally witnessed. I would never recommend someone doing that, but they do have their place if it's a last minute situation where someone needs to write something down. But a will is indeed a legal document. It's an expression of wishes um, for what's to happen with your finances. Um, Generally, what we'll see with wills is various administration clauses, where there's powers and the ability to do certain things, such as making tax elections, um, deciding on valuation, um, and various clauses that allow the executor to proceed in the best way possible. Um, Generally, a lot of times, I should say generally, a lot of times, they do include a trust. Um, a trust that's embedded within a will are called testamentary trusts. Just like the old term of last will and testament, um, that's where we get the term testamentary trust. So essentially, a will is giving away your finances for assets that are considered to fall within your estate. Um, Now, many people have RSPs or other registered plans like TFSAs, life insurance, things of that nature, where there will be beneficiary designations. Those, unless the will overrides those designations, are considered to fall outside of what your estate is. So, in very simple terms, in a lot of provinces with high probate fees, such as our neighbors to the west, like British Columbia, Nova Scotia, Ontario, some of those jurisdictions have high probate costs. Probate is the process by which the courts will validate your will. Your will does have legal authority on its own. However, in a practical perspective, financial institutions or other third parties will want to know that that will that's being presented to them for that money to be accessed is legitimate. It is the last will, and the only way of knowing that you're protected is for that executor, who is the individual who's named in the will to act, is in possession of the last valid will, and that grant of probate by the courts it will validate that, and it's a protection for that third party to You take instruction from that person. That person's named the executor, and every province in Canada um, has different estate legislation. So it really depends on where your estate uh, your estate is. The rule essentially in every province is that wherever you're domiciled or wherever you reside, that's where your primary grant will be uh, applied for. So lots of people will have assets outside of the province they live in. So real estate's a good example. Um, you have a will in the province that's drafted where you live, and you'll use that will for the assets wherever they're located. But every province has different uh, costs in terms of that court application. So in Alberta, we're lucky the probate costs, the filing fees, not the legal fees, are quite low. They max out at I believe it's $550 for any estate over $250,000 is my recollection. Other provinces like BC, they're a percentage of the estate value. Um, when I talk about the estate, again, those are anything that does not have a beneficiary designation, such as a registered plan or life insurance, unless your will or that beneficiary designation designates your estate as the beneficiary. I can answer any other questions later if people have questions about that. Estate planning is the process that one goes through, not just drafting your will, but uh, getting your wishes together, setting out what your assets are, what you have, how it's held, who you want your beneficiaries to be. You want your will to be clear, but have some flexibility, and I'll speak to that in a minute. You want to make sure it's practical. Um, I've seen lots of situations in will drafting. I've read thousands of them in my time, and sometimes it just gets quite impractical in some of the wording in there. You want to keep it fairly practical, um, and really, in my opinion, is have a level of trust of who you appoint to make those right decisions. I've seen lots of what we call in the industry dead hand control, where people want to rule the disbursement of their assets from the grave. And sometimes that can be very, very impractical and can go on for years. There's also some tax implications for some of those things, but that's outside the scope of this. Estate tax, estate planning, probably your biggest uh, uh, thing to focus on is try to minimize the estate tax. Um, in general terms, um, the worst tax year of your life is the last year on the planet. So your terminal tax return is when everything that has not yet been disposed of is deemed to be disposed of. And so there are methods of minimizing estate tax, but generally that's the worst tax event is when you die. For example, just a one quick example, if you have a registered plan that's tax deferred, like an RSP or a RIF, that entire market value on the date you pass is deemed to have been disposed of and added to your income. So if you have a RIF, a large RIF, let's say it's 500,000, that $500,000 RIF gets added to your terminal tax return in the year of your passing, and you're now bumped yourself up into the highest marginal tax rate. So there's a significant tax liability there. So this is all about estate planning, thinking about how you can minimize it. Um, in terms of decision making, besides picking your beneficiaries, doing that estate plan, you have to think carefully about who you want to appoint. And as I mentioned or alluded to, um, your executor does everything from closing those email accounts, changing the insurance on the property, inventorying the items in the property, liquidating the assets if they're not specifically gifted in the will, selling that property, selling the vehicles, changing insurance, making sure the insurance is appropriate. I mean, you name it, it's absolutely everything. So the executor is responsible for anything to do with your financial life. Um, and so really that is the role, and it's very time consuming. I know I've done it not only in my career, but in my personal life with family members. It's a huge, huge responsibility, not to mention the emotional impacts of dealing with someone's passing and other family members. In my experience as a corporate executor, I see lots of situations where families get torn apart. There's a lot of animosity, and now that once that glue perhaps is out of the family, such as a parent, sometimes the hidden animosity comes to the surface, and money doesn't sometimes and many times causes some animosity in terms of fairness and how things are handled. Um, what are the risks? A lay executor, so someone who's not a professional, uh, is a fiduciary, is the term we use. So they have to act in the best interests of the estate and the beneficiaries and have a duty of loyalty to the beneficiaries. So treating everyone equally, despite how you personally feel about them, and being above board and fair. Um, from a layperson, they're not held to the highest standard like a corporate executor would be, such as Solus Trust. We do act in that capacity, or any of the corporate executor options that are out there. But there are risks indeed. For example, just to give you one quick example, if you disperse the entire estate without getting a clearance certificate from Canada Revenue Agency saying that all the tax liabilities are paid, you can be personally liable out of your own pocket for the shortfall that's still owed. That's one quick example of the liability. Corporate executors are like lawyers in the sense where uh, they are professionals and they are deemed to or expected to act in a professional manner and not incur any losses. So there is a higher expectation for a corporate executor. Um, and um, and the beauty of having someone appointed from a corporate perspective is that that if there is a mistake made, they'll make you whole. Not that there's ever a situation where you're making mistakes, but just like if a lawyer makes a mistake, you can rely on their insurance. It was very similar. What should you consider um, when you choose an executor? Well, residency is important because I mentioned that state law is provincially legislated. You want, not only from a practical perspective, someone who's resident near where you live so they can access the property. Um, um, we want to think about the cost of traveling to the province or within the province to deal with those things. Those costs will be borne by your estate, so you want to think about that. You also want to think about it from a tax perspective. An estate itself is considered a trust, and whoever makes the decisions on that trust, i.e., the estate, that's where CRA, the Canada Revenue Agency, will deem the trust to be because it's no longer an individual, it's a legal entity. So if you have an executor that's out of province and they say, for example, live in New Brunswick, then the CRA will deem the trust to be resident in New Brunswick, subject to that province's or country's tax laws. Um, the other consideration, which is probably perhaps more important, is that the courts, when you apply for the grant of probate, if you have an out of province executor, there is a default requirement for that executor to post a bond for the entire value of the estate to the court to ensure that remedy is there in case the executor absconds with the money. Um, that can be quite expensive, obtaining that bond, particularly when you're talking about a sizable estate. So something to consider. I would never recommend an out of country executor, such as our friends to the south. You're now bringing the IRS involved if you have someone resident in the US, and now you have to rely on a tax treaty. So really something to consider when you're trying to pick someone. You want to think about family dynamics or the conflicts within the family. And as I mentioned or alluded to, children tend to be civil with each other for the benefit of the parents. But when that glue is gone, once the family member is deceased, there could be some family dynamics. I've seen lots of that. Is your executor a good decision maker? Lack of decision making can be just as bad as a bad decision. um, I've seen situations where you want someone who can make those decisions, those hard decisions, and not get emotionally attached to a particular asset or have real solid ideas about what, say, mom and dad wanted. You want to adhere to the legalities of it. What does the will say? That sort of thing. Um, and you want someone who's an informed decision maker, someone who's going to ask the right questions and seek the right advice if they don't know. Um, Interestingly, when we look at number 4 there, conflicts of interest, there's no law or rule in place that says you can't put your executor in a conflict of interest position. For example, I've seen situations where maybe a family member has a disability, they name a sibling as the trustee of that trust within the will for that share going to the disabled person. Sometimes they'll set it up as a life interest so they get to use the money for their lifetime, but then ultimately the money will flow back to that sibling who's in that trustee role. Inherently, there's a conflict because whatever money's not spent for that disabled beneficiary will benefit that trustee, and so they are in an inherent conflict of interest. Probably something to consider when you're thinking of who's going to act in these capacities. Time to do the work. Number 5, very important, particularly not to pick on someone or an organization like CRA, but I think we've all experienced trying to get a hold of CRA, sitting on hold, waiting for callbacks, doing those things that take that time that you can't do on a Saturday or Sunday, and you need to find some time during the week. Time is money. It's a big, big responsibility. Finally, number 6, you want someone generally who's younger than you, because you don't want to appoint someone who's not around if they're older than you. Um, at the very least, name an alternate. So if that person you name is not around, please name an alternate or a second alternate so you don't end up having a situation where you have a will but a vacuum in that capacity of executor. What does an executor do? There's a whole bunch. This is just a quick snapshot. Um, Obviously have to read and interpret the will, safeguard assets. That's the big thing, particularly with real property. Let the institutions know that hold the assets that they've passed, providing the death certificate, freeze those accounts. Locate the assets and debts. As a corporate executor, I've seen situations where we have to do a bit of a search, do a mail redirect when there is mail, find out where all the assets are, get date of death values, file that inventory with the courts, do an appraisal of the assets, determine the legitimacy of any debts, because there may not they may not be a legitimate debt. You get people coming out of the woodwork saying, well, they owed me money. Seen that many times. Make sure the insurance is amended or apply for it as necessary to preserve the assets. Reviewing contractual agreements, notifying your beneficiaries, um, answering questions they may have, advertising for creditors in the newspaper, and there's law around that. Obviously, applying for probate, filing and paying the taxes. Probably the biggest thing that's in an estate administration, and then closing off all the services and contracts. Um, even trying to get a hold of these utility companies and getting things canceled, making sure that you're getting the refunds appropriately. Did I mention opening an estate account? I could go on and on. You're going to be dealing with professionals, real estate agents, appraisers, accountants for tax prep potentially, selling real estate. Auctioning off or dealing otherwise with household personal assets. Usually that involves going to the landfill, to charity, dealing with digital assets. That's another big thing now. People have their life on their computers. You want to get those accessed to review. Keeping an estate record of accounts. You are required to keep formal accounting, and if the courts ask, you must provide it. Settle or litigate claims. Communicate with beneficiaries regularly. Um, Making those distributions. Deciding how much you can pay as an interim and a final. Exercising discretion. Um, and then getting court approval if where necessary. Sometimes you have to make an application for advice and direction through the courts, and of course, applying for a final tax clearance. By no means is this an exhaustive list. These are just some of the many things that the executor has to do. So again, location is big. You want to pick someone who's local, that has the knowledge and skills, that has the time, has that objectivity and independence, is of a certain age, and is able and willing to do it. I would always recommend speaking to someone and asking them if they'll do it before you appoint them. Um, you want to consider the complexity and the types of assets. So, for example, in my experience, I've done lots of corporate windups where people have private company shares. There is a level of complexity in avoiding double tax on the windup of those corporations. I would highly recommend, if you have a private corporation, to employ a corporate executor. Trust me, it will pay for itself because CRA will has imposed deadlines and timelines for things to get done. And if you miss deadlines, they're not sympathetic in allowing you to do certain things. We call that post-mortem tax planning. Very important. From a more simplistic perspective, about charitable donations, there are mistakes that can be made if you don't donate assets strategically. For example, you can donate shares in kind to satisfy a requirement in the will to make a donation, say fit the estate, etc. So if you have somebody who's maybe not as familiar with that, doesn't ask the right questions, you can lose the estate some money. Estate planning essentially it's more than just a will. It is important. It is your legacy. Your legacy is important, and I think it really behooves everyone to choose the right executor. Um, uh, there's lots of options out there for corporate executors. Solus certainly does that. We are affiliated with Raymond James. If you're a Raymond James client, you also get a discount for the prorated portion that's under the Raymond James umbrella. But we're also an independent trust company, and we'll work with any institution out there wherever the assets are. For example, if there's funds elsewhere. And just a bit of a plug for who I work for. Solus Trust has been around since the early 80s. We've been around for quite a long time. There's that longevity piece. Um, this is what we do. It's our bread and butter. We're very efficient in what we do. We can wind that estate up fairly quickly, and we have a team behind us. We're also, because in the last 3 years when we were purchased by Raymond James, we gained a huge back office of cross-border, i.e. US assistance in our back office, which I think is really, really important as well. So we have in-house tax folks, we have financial planners. You get a big bench strength team behind you if you were to appoint a corporate executor such as Solus. We act as executor. We can be named as a co-executor, a primary, an alternate. We also do power of attorney work. We can be named as a power of attorney, which is subject of another presentation at some other time. We can act as trustee of trusts in wills. We can also act on inter vivos trusts. Those are trusts created during your lifetime. And then we also provide a service called Simplify, which um, for those who have, say, more complex lifestyles because of the wealth they've gathered, we can take over the finances in an informal role, similar to a POA, but we don't have the legal authority behind it. And I see that uh, quite frequently for folks that maybe are concerned about, say, their spouse not knowing where all what all needs to get paid, and they want to get things set up now so it's seamless. Simplify is also something that we offer where we can assist named folks such as executors or attorneys. We can help them along the way and act as their agent, but they still retain the control. So if you yourself have been named and you don't know what your next step is, give me a call. We can talk about some services we offer. And there's me, my not a very great picture of me, but anyway, that's me and my contact information. So maybe what I'll do is maybe I'll pause and do a bit of a Q&A. I didn't get to see the questions as they came because I was busy presenting, so I'll just pause there, unshare my screen for now, and just answer any questions that folks have.
Thank you very much, Craig. No questions have come in yet, so give folks
Okay.
a minute or two if they want to find that Q&A button and type in any questions. In the meantime, I'll say thank you very much for presenting today. Obviously not the most exciting or glamorous topic, but very important nonetheless, and I think you touched on some of the reasons why. So. Much appreciated. And then for anybody on today who's either a client of mine or of Steve and Karen, by all means reach out to us and we can connect you with Craig for further discussion as well. Okay, we got a question.
Hmm.
Um, Curious, what are the costs of these various services, and what size of estate, would you say it would be appropriate to, start looking at a service like Solus Trust?
Yeah, it's a obviously a good question. I've worked for one of the big five banks and come over to the independent side as well, so I'm pretty familiar with what the market charges. Generally, what we see for corporate executor services is an estate value of $1 million minimum, with some flexibility on that one. But that would include real estate as well. So the threshold when you add real estate in is not as uh, difficult to reach these days, particularly with real estate the way it is. The rates, any rates I've ever seen, they are all dependent on the estate value. So it's a percentage of the estate value. So as that value increases, the percentages uh, decrease. Okay, so um, well, I can speak for Solus. It's 0 to 3 million. There's a percentage threshold, and usually the way it's set up is the first 500,000 there's a certain percentage, and the next 500, the next 500, etc. Once you get to this over three, there's a 3 to 5, and then a 5 to 7, etc. So ultimately, and I'm happy to discuss this with anyone's particular circumstances, but it usually works out when you run the numbers, and I could quote folks, it usually runs around the 2.5%, 2.5, 3% range or less, which is right in line with what the courts have said is a reasonable fee for executive services. So even if you appoint a layperson, there's what's called the surrogate rules, which is part of what's called the Judicature Act of Alberta. And they have a committee that keeps an eye on legal fees and the costs of these types of things. What they have said and has been sort of, wouldn't say codified in law, but reasonable fees for acting as executors anywhere between 1% and 5%. So when I talk to people and they say, okay, um, you could name a layperson to do it, they can charge in that frame, a range. So we come in right at the lower end of what the courts have said is reasonable because of the work involved. So, it's not the sexiest sort of purchase one will make in their life. Um, but I think you're giving a gift actually to your beneficiary. It's a gift of time because it's more efficient and you're not putting someone in an awkward position. So there's a cost for everything. Um, but when I look at some of these fees, for example, let's say if it's a $50,000, if you do the math, fee on a fee administration, when you think about the cost of hiring a real estate agent to sell your house, I think the cost is quite reasonable when you consider it all and the peace of mind that comes with it. So, but whoever's asking or wants to know, I'd be happy to do a quote for folks to give you an exact idea what it would cost.
Perfect. Thanks for the answer, Craig. Next question. Could you be a little bit more specific about who besides you and your company can be called upon to be executor? And what would this be called? Corporate executor? Question mark. So yeah, like who would be the competition to Solus Trust? And what are there any other options other than naming a family member or a corporate executor?
Yeah, good question. Well, I can tell you the big five, all the big five banks all have that service. One of the things, um, I'll give you, here's an example that sets Solus apart is that as an independent, let's say someone has assets at various financial institutions and they want, let's say there's an investment at outside of Raymond James and it's at one of the big five banks. They want that to be form the trust for a family member. The big five, the competition will bring it under that umbrella and they will insist on it being managed out of that financial institution. As an independent, we'll keep it where it is and I'll work with anybody. It would be me if I'm still here, I'm in Alberta. I would be the face of Solus Trust here in Alberta with my back office across the country. So my back office, the ones that do all of that paperwork is in either in Toronto or Vancouver. But we've expanded here into Alberta, where it's myself. I'm in Calgary. I'll travel to wherever the property is, which means we get someone local on the ground, which is fairly new for us. So we're expanding our services. We are across Canada. We do have that bench strength of Raymond James back offices in both countries as well. But to answer your question, it would be me or my counterpart, Damien McGrath, who's out here frequently, but it would be someone local to Alberta that's going to be going out there. And if it's an immediate fee business where I'm jumping right in, I would be the one dealing with your family and your assets.
And the service is called Corporate Executor Services.
Correct. Yeah. Yeah.
Uh, could you give a quick recap of why an out-of-province executor is not a good idea?
Well, two reasons. One, the probably the most pertinent would be the bond requirement. So I believe it's the Estate Administration Act. I forget the section, but it will say that if you're not a resident of Alberta, at least if you have co-executors, as long as you have one executor in Alberta, then you're okay. But once you name someone who's got the final decision-making power, they're not in Alberta, they're now a resident outside the province. And so that's where the bond requirement is required. You have to post a bond unless you ask the court to waive that requirement. If you have minor beneficiaries that have an interest in the estate, um, I can tell you from my previous experience at the public trustee, they will not agree to waive the bond because there's a minor who's under what's called a legal disability. So you want to bear that in mind. That bond requirement can be expensive, or the bond requirement is expensive, and that gets charged against the estate's assets. So it can be costly. Secondly, because an estate is not a person and it has no address, the legal entity of the estate, the trust, is resident where the mine and management of the estate is. So if you have someone in New Brunswick, for example, or Ontario that maybe have higher tax rates, your estate's going to get taxed at that particular jurisdiction's rate of tax. So it's twofold. Hopefully that answered the question.
For sure. I have a question myself as well. So you had mentioned there's also the ability to hire you as a helper without naming you as the actual executor.
Mhm.
If the family dynamic was that, kids were living in different provinces and the parents passed away. Maybe there's one person that's already named and they're unfortunately in the wrong province. Is that something that you guys can help out with as well?
Oh, absolutely. So we call that an agency relationship. We call it simplify, but it's within that umbrella of service. It's called trustee support or executor support. So we can be hired as an agent and do all the dirty work for them. That person would still be the decision maker. They would agree to appoint us as an agent, just like a sports agent. And we would then, with that signed document, be able to liaise, do all that hard work. Um, and when we just need a signature to take the next step, we would reach out, get that signature, and move forward. So it's a middle of the road solution. The fee structure is very similar to what the naming of a corporate executor would be. It's very, very similar because ultimately we're doing the same amount of work, if not more, because we have to constantly be in contact with the named executor. And that could be for the trustee as well. So if you find yourself in that situation, I'm happy to talk to you about what that would look like.
Perfect. And then is there a fee for a quote on services?
No fee. So what distinguishes us from some boutique firms that I know are out there that will provide like a free seminar and then they'll charge you to sit down and do an estate plan. Um, we don't charge for any of the services for the quotes for a quick discussion. Um, so, for example, if someone wanted to name us as a corporate executor, I would sit down, go through the process, talk about estate planning, bring the other experts to the fold. If you wanted to name us, that's no charge. The only time we get paid is when we begin to act. And again, this is not a contract. This is an agreement that if we were to act, that's what the fee would be. So sometimes people decide they get that free advice and decide years later they want to change their mind or 6 months later. All they need to do is change their will, appoint someone else, and we're out. It's a risk we take. We hope you don't do that, but it's not something that you're locked into.
Perfect, thank you. I'll just mention as well, both Craig and Damien have talked with some of my clients in the past just for high level informational gathering, and they found that to be really valuable. This is available to all Raymond James clients at any time. You would just contact your advisor and book that call. I don't have any more questions as of yet, so I will just close it out by saying thank you to everyone that participated today. Thank you, Craig, for presenting. We will have some more webinars coming up on other topics, so keep an eye out for those. And if anyone has any follow-up questions or they want a replay of this webinar, just let us know. Hope fingers crossed the replay will be saved and we can share that with friends and family that were unable to attend today. So with that, yeah, that's it. No more questions. So thanks again, Craig. Thank you to everyone that showed up today, and we'll let you guys get back to your day and appreciate your time.
Yeah. Thanks, everybody. Take care. Thanks, Greg. Bye bye.
Take care, everybody.